the ones who owe the obligation, are all liable for up to the entire amount of the obligation under the contract.
Welcome to the Contract Teardown Show from Law Insider, where legal experts tear down contracts from some of the most well-known companies and high-profile executives around the world.
In this episode, attorney Diana Isyanova tears down an amended loan agreement. She focuses on the liability section as we tease a new resource on Law Insider. We'll tell you about that and go deep on joint, several, and joint and several liability. So let's tear it down. Hey everybody, welcome back to the Contract Teardown Show from Law Insider. I am Mike Whalen. The purpose of the show is exactly what it sounds like. We take contracts and we beat them up, often mean, occasionally nice to them. It's not very common. I am here with my friend Diana Isyanova. Diana, how are you today?
I'm doing well. How are you?
Good. I am excited because, spoiler alert, we're going to talk about a subject that you and I worked on to create a really cool resource that we will share at the end that it's coming. It's cool, so you guys should stick around. But before we do that, we're going to whet the appetite. We were talking about a document. Let me share it with them, Diana. It is this document. Amended and Restated Loan Agreement by and among residential for blah, blah, blah. It's a residential capital loan agreement. And specifically what we're going to focus on today for reasons we will get into is the liability, joint and several liability stuff. So, Diana, before we dig into it, why? Why are we talking about this document? When are we going to see it? Why is it important? We'll then dig into it. But tell me about what this document is.
Sure. So, as you said, this is an amended and restated agreement between a group of lenders and a group of borrowers. It is a well-written agreement, and it's about 80 to 90 pages long. But it shouldn't surprise you because we're talking a line of credit of over 900 million.
Yeah.
So, yeah. It's kind of important to draft a detailed agreement with clarifying all the terms and outlining some of the possible scenarios.
Sure. Yeah, they dot the I's on that kind. So, yes, a very good and long document, which is sort of depressing because I like to beat up bad documents. That's more fun. But we're talking to you for reasons. Tell me about you, about your practice, your background, what brings you to documents like this, and this issue of joint and several. Just tell us about your background.
Okay. So my background is in transactional law. I enjoy contracts of all sorts. I enjoy drafting them, and I enjoy reading them. Even before I decided to go to law school, I would often read the fine print on the consent form at the doctor's office rather than reading a magazine or something. So after getting my license, I joined a large international firm where I did mostly transactional work. I left the firm right before the pandemic. Like everybody else, I had to stay at home, and I have 3 young daughters at home. And I didn't have a job, and I really couldn't get a job because of my children. So, but once I got a handle on the situation with managing my kids, keeping track of their Zoom classes, and trying just to stay sane, I began doing some legal work for my friends and family. Then I got my paying client, then another and another. And before I knew it, I was practicing solo full time.
I love my kids are driving me freaking crazy. They're obnoxious. School is obnoxious. I wish everybody would go away. I'm going to go review some contracts. Like as your outlet for, I'm tired of this crap. Let's go review some contracts. All right. Well, we're going to dig into this particular document. And like I said, we're teasing a bit, a really cool resource that we're going to tell you guys about at the end. But before we do it, I know you wanted to talk about the definitions section at the beginning. Dive into that a little bit. Tell me a bit of the background. What are you seeing in that section?
Sure. So to just give a little bit of background for the contract itself, the story behind this contract, they had 3 original parties, right? The original agreement was called Original Loan Agreement, and it was entered among the lenders, guarantors, and borrowers back in November 20th, 2008. Then the same parties entered into another agreement dated June 1st, 2009. And now these parties wish to consolidate those two agreements with certain changes. So that's the backstory. And when I looked at this agreement briefly, I was surprised because the definition portion was so short. I was like, this is kind of unusual for a contract of this caliber. But then I looked closer and there was a Schedule A that is comprised of about 35 pages. And that's where all the terms are defined. And this is really common because in this contract, every word matters and it has to be defined precisely. So there's one interesting part in the short part of the definitions. It defines the word include, includes, and including. And it says that every time we use that word, it shall be deemed to be followed by the phrase without limitation, which is, it makes complete sense, right? Like no one wants to read those phrases over and over and over
Sure.
again, like including without limitation or included but not limited to. But at the same time, it is an important phrase, and it precisely states that a specified item, a specified term, is not limited to the stated in writing parameters. So I thought it was a great way to avoid repetition in the document and also to save some space. I think removing just those two words saved at least half a page, if not more.
Hey everybody, I'm Mike Whalen. I hope you're enjoying this episode of the Contract Teardown Show. Real quick, I want to ask you to do me/you really a quick favor. Look down below. You'll see a discount code to join the Law Insider Premium subscription. When you do that, you get access to more content like this. You'll see webinars, daily tips on contract drafting, not to mention access to the world's largest database of sample contracts and clauses. It will help you write better contracts faster. If you want to do it right now, there's a code below, so get there. Also, if you're part of a larger team, if you're in-house or in a law firm, just email us. We're at sales@lawinsider.com. We'll make sure you get a deal as well. Come join us in the community. The code is below. Let's get back to the show. God, what an interesting thing, because you could probably do that over and over again in a document this long where you're like, hey, when we say what we really mean is this really long, obnoxious legal phrase. And so just assume that we mean long, obnoxious legal phrase. That's sort of a cool way to do it. All right. Now, we're getting into some nerdiness, and there are reasons, but we're jumping down to the liability section and this issue of joint, several, smessural, flavolor. I'm just making up words now. Those are not actual words. All right. Give us just like the briefest, before we dig into this section on this liability section, give us the briefest definition of these different terms and how lawyers run into them. Tell us what these terms are.
Okay. So these three clauses, they may get confusing, even to lawyers. But it's even more of a reason to learn about them and understand them, right? One of the main reasons people enter into contract in general is to limit their liability or to have assurances that if something goes sideways due to the fault of the other side will be held liable. So joint and several liability are three distinct clauses. Each has its benefits and each has its place in contracts. Joint liability arises when two or more parties promise to be jointly liable for the obligation under the contract. For example, if A and B are jointly obligated to pay C, let's say $1,000, and if A or B breaches, then C can choose to recover from A or B, regardless of who is actually at fault. So in this situation, each A and B will be liable for the entire $1,000. But once the full amount is paid by either party, both of the parties will be discharged from their contractual obligation. And of course, C cannot recover the $1,000 from A, who was not at fault, let's say, and then turn around and sue B, who was actually at fault. So once the full amount is recovered, the deal is done.
Yeah, well, in a contract like this where you got multiple parties, I mean, it's important to figure that out. So what we're going to do is, like we usually do, we'll jump right down to the text. This clause is found in section 13.12, and it's titled Joint and Several Liability of Borrowers. It refers to each borrower. So I'll start with the sentence, each borrower acknowledges and represents that its business is integrally related to the business of the other borrower, that the availability of the commitments benefits each borrower individually, and that the loans made will be for and inure to the benefit, I love that word, of each of the borrowers individually and as a group. Talk to me about this section. What is it telling us about the relationship between these parties?
So it's setting the stage for joint and several liability. And joint and several liability is when the parties, the obligors, right, the ones who owe the obligation, are all liable for up to the entire amount of the obligation under the contract. But, and that's an important but, the responsible parties have the right of contribution, meaning that they can recover from the non-paying party, from the non-paying obligor, with whom they're jointly and severally liable. They can recover a portion or the entire amount. So to summarize what you just read is each individual borrower will be held liable individually, and as a group, because they benefit individually and as a group. And it just makes sense to hold them liable individually.
So the nature of their relationship in this deal is what is sort of predicating, okay, what kind of liability is right for that? So I would assume if I'm a lawyer and I'm drafting this kind of thing, A, I need to determine that. What is the relationship? And B, that is it a good idea in this case to really explicitly lay out, these things are true about your relationship, right? So if it's tied to the liability choice, should a lawyer very clearly state like this is the relationship that we're basing that decision upon?
I think it's a good idea, especially in these long contracts. It's definitely a good idea to set the stage and kind of reinforce, those important terms. It's okay to state what you want the provision to say, but it's also important to say the inverse side, what the provision is not meant to say.
Right.
So in here, after the stage is set, the following sentence goes, accordingly, each borrower shall be jointly and severally liable. And here, in parentheses, it reinforces again, it says, as a principal and not as the surety, guarantor, and other accommodating party. So here in the parentheses, it reinforces that each borrower is a principal to the obligation and not just to accommodate some other obligor. So this ensures that the cosigner will be primarily liable for the obligation. And if and when it becomes necessary, landlords in this situation can recover from each or any borrower directly.
So thinking about this background thing then, how can the parties define, if this thing puts them both in a bundle, they might not like that. They don't want to be liable in this sense. Is there something that a lawyer can create to sort of define the nature of the liability between those parties?
Absolutely, yes. And that's the main issue here under joint and several liability. They do have this right to recover, but it's extremely important to have that right sorted out among themselves, right? For instance, if A and B are jointly and severally liable to C, A and B need to have a separate agreement, sometimes called a contribution agreement, for complex transaction involving many co-parties, which this is,
Right.
it is normally a standalone document. But for simpler, more straightforward transactions, it could be just another provision in the agreement. So to have it sorted out is important because in case C, or the landlord in this case, chooses to only recover from one obligor, which often happens, by the way, because sometimes one of the obligor has the deeper pocket and it's just easier to recover from them. A need to have rights to recover from B. So how much to recover, what percentage or specific amount, when to recover, and under what conditions and limitations, all of this need to be clarified in that separate contract.
Right. Yeah, and jumping down in this document, I mean, it starts talking about these contributions. It says any borrower that makes a payment or distribution hereunder will be entitled to a contribution from the other borrower in a pro rata amount. Tell me about that section. What are you seeing in this conversation about contribution?
And that's exactly right. So this provision specifically states that yes, you're jointly and severally liable, and we also want to mention that you have this right to contribution. But it doesn't go any further, like describing how it's actually going to work if one of the obligor has to pay. And I'm sure the borrowers, they have numerous problems, not a single one, numerous agreements on the side describing how they're going to apportion that liability and who's going to compensate who if one is held liable. So in that separate agreement, it is very important to clarify the rights. And it's especially important to mention things like interest on the amount that not paid by the obligor who actually was at fault, and probably even the right to recover attorney fees if forced to litigate to recover. In general, at least in California, attorney fees are not recoverable without an explicit provision.
Yeah, and I'm jumping down to the remaining language in this section. It talks about the provisions of Section 1312 shall in no respect limit the obligations and liabilities of each borrower to the lender parties, and each borrower shall remain liable to the lender parties for the full amount of the obligation. So what's the purpose in this kind of a sentence in terms of, again, sort of limiting the limiting the, I don't know if limiting the liability is the right phrase, but what do you see in that sentence?
So yes, this last sentence in a paragraph also just reinforces that if one of the obligors, one of the borrowers, defaults or breaches the contract, the landlord can go after any of them and can hold liable any of the borrower for the full amount.
Okay, so this is a very cool document. It's well written, as you said. There's a lot to it's freaking long, right? I mean, a lot of lawyers are not going to be dealing with this kind of a document with these kinds of stakes. And so there are decisions to be made, and sometimes those decisions are not explicit, right? People don't say it's either joint or several or joint and several, et cetera, et cetera, et cetera. What if it's not there? What do we do then? Are we falling back on state law?
Yes. Well, first of all, a contract should specify what type of liability. But if it doesn't, sometimes joint and several liability can be presumed under state laws. For example, in absence of clear and explicit language in the contract, California courts will presume joint and several liability when all liable parties benefit in some way from the past or present consideration, which is the bargain for value. A co-signer of a promissory note is also presumed to be a co-obligor and not a guarantor, and will be held jointly and severally liable, meaning the co-signer will be primarily liable for the obligation, where a guarantor is not liable unless and until the underlying borrower defaults.
Right.
So even though these presumptions are not conclusive, and may be overcome with sufficient evidence indicating otherwise. Needless to say, again, such presumptions should not be relied upon when drafting or signing an agreement, and an express provision on liability that accurately and completely describes the intention of the contracting parties should always be preferred.
Got it. And that's why my mom won't sign on to any of my loans. Okay, I am going to spoil. I'm going to alert you to the spoil, guys, about what we've got coming before Diana, I ask you the last question. So what we have coming is Diana has written a really cool guide on this issue, on joint and several liability. It's an ebook, and it's pretty long, and it digs in. You can find it over at lawinsider.com/resources. It will be part of our Key Clauses series. So we're going to do a series of these ebooks, and you can find them all over at the resources section of Law Insider. Okay, so Diana, in closing, I want you to give me a taste of that ebook, of some of the advice that you give in that ebook. What kind of practical suggestions would you give if somebody's making this choice in a document? I'm drafting, I've got to pick joint or several, or joint and several, et cetera, et cetera. How do I make that choice? Any suggestions on that, just to give us a taste of what that ebook's got in there?
Sure. The ebook includes some of the drafting considerations, how you want to draft, how you want to word those provisions. But when you're choosing between the three, there are really two major considerations that should be taken into account. One is who owes the obligation, and two, the allocation of assets among the obligors, right? So the parties to whom obligation is owed should prefer either joint or joint and several clauses. This would afford the obligee, the landlord in this situation, the choice of which obligor or borrower to sue, right? Naturally, the obligee would likely choose to demand payment from the most financially able party, and it's just easier. It saves a lot of time and saves effort of pursuing all the parties, right? And some of the parties may not be even solvent enough to satisfy the debt. Right. It also removes the need to deal with the apportionment among the obligors, so it's none of the lender's concern. He'll be able, or she'll be able, or it will be able to recover the amount it's owed.
You can tell it's a nerdy conversation when we use obligee in a sentence. That's what the cool kids do. All right, Diana, again, guys, if you go to lawinsider.com/resources, you will find this and other ebooks as we add them in the Key Clauses series. So I want people to do that. But Diana, if people want to reach out to you and nerd out very specifically about the things you nerd out very specifically on, what's the best way to connect with you?
I would love to receive some emails. It's Diana@isyanovalaw.com.
Awesome. And we'll have that information and a link to this contract and a link to the ebook over at lawinsider.com/resources. We'll create a robust blog page about this, as we always do. If you go there, you'll see transcripts of these conversations. You'll see links and details. Go hang out at the blog. It's a really good place. So we will see you guys next time. Also, though, if you want to be a contributor, if you want to be on this show and nerd out with me about stuff like this, just email us. We are at community@lawinsider.com. With that, thank you, Diana. We will see you guys next time. Have a good day.